Here's the judgment of this court. Was commenced general form of complaint, which was filed on the 23rd of April 2019, along with a statement of facts, list of witnesses, witness statements and oaths, list of documents, and copies of the listed and the statement of fact. The claimant's claims against the defendants as follows. Reading out of the River State, Right Honorable Rotimi Chibuke Amechi, appointed him secretary to the board and authority of the first defendant. He added that the appointment was for an initial period of 4 years in the first instance and subject to reappointment for another term of 4 years and no more. The claimant averred that his appointment had statutory flavor and it was pursuant to Section 10, Sub 1, 3A of the Greater Port Harcourt City Development, also governed by the defendant's staff handbook. The claimant added that upon the expiration of the first term of his appointment in May 2013, he continued in office as secretary to the knowledge of the governor. And before the expiration of his first term, he wrote a letter dated 2nd of (2013), when he received the letter from the administrator of the first defendant, Dame Aleruchi Kuki Graham, purporting to remove him from office. The claimant added that he received the guarantee trust bank check made out in his favor in the sum of 5,724,000 naira, which he reluctantly received as same was far less than what he is entitled to. The claimant posited that had he not been forcefully removed from office, he would have been secretary till 2018 and would have been paid his remuneration, allowances, and other entitlements. Upon cross-examination, the CW1 posited that he was orally instructed by the defendant to carry out a report, and the instrument given to him were the defendant's handbook, the claimant's appointment letter, and oral information. The CW1 added that he signed the report and that he contacted the HR department of the defendant while admitting that the 6 years he wrote in the report was an oral information from the claimant. The CW1 admitted that the approval for severance benefit, redundancy, and compensation are at the discretion of the governor. while also admitted that the handbook specified nothing for the secretary, but he used his initiative to compute as he prepared the document for the purpose of giving it to the government of the Rivers State on behalf of the claimant. Upon further cross-examination by counsel to the second defendant, the CW1 admitted that he knows that the claimant is an appointee of the first defendant and not an employee. He also admitted that the chairman and secretary are exempted from being an appointee. On several occasions for the claimant to continue his trial to appear, and upon the application of counsel to the defendant to have the claimant foreclosed by virtue of 38 Rule 9 of the Rules of Discord, the claim defends on the 3rd of February 2021. The first defendant, in opening their case, called one witness, the person of Marshall Webilo, as W1, who adopted his witness statement on oath, which was marked as D1. Through the said DW1, 2 documents were tendered and admitted in evidence as exhibit D2 and D3, with the arising from the state. The case of the first defendant is that even though the claimant was appointed as the pioneer secretary of the first defendant board via a letter dated 11th day of May 2009 by the then executive governor of Rivers State, Right Honorable Rotimi Chukwuka Amechi, for a term of 4 years, the said appointment was not subject to automatic renewal, and it automatically expired on the 10th of May 2013 by fluctuation of time, subject to renewal at the pleasure of the governor. The first defendant averred further that rather than renew the appointment of the claimant, the then executive governor, Right Honorable Rotimi Chukwuka Amechi, reconstituted a new board in July 2013 with a new secretary to the board of the first defendant, while also positing that the appointment of the claimant was never covered or governed by the first defendant's staff handbook, as erroneously claimed by the claimant. The first defendant added that the appointment was not prematurely terminated, but rather it ran a full course of 4 years, as provided by the provision of Section 10 sub 1 and sub 4 of the Greater Port Harcourt City Development Authority Law number 2 of 2009, and that the claimant was paid all his entitlement and benefits to the tune of 5,724,000 via a guaranteed trust bank check, which he signed and collected, only to turn around to make bogus claims on the first defendant. Upon cross-examination by counsel to the claimant, the DW1 admitted that the claimant's appointment was for a term of 4 years and it expired since 10th of May 2013. DW1 posited that it was not possible for the claimant to still discharge duties as secretary between May 2013 to October 2013. He also insisted that the entitlement for reappointment is discretionary. Upon further cross-examination by counsel to the second defendant, the DW1 admitted that the claimant was a political appointee whose appointment and reappointment was at the discretion of the then governor. DW1 further admitted that when the claimant was appointed in 2009, he was given an appointment letter, and when his tenure expired, a new board was constituted. While the claimant was not reappointed, but was paid all his benefits. Upon the discharge of DW1, the defendants closed the case and the matter was adjourned for adoption of final written addresses. On the 14th day of July 2021, the first defendant filed a final address, arising from which the counsel to the defendant, D.A. Jaja Esquire, formulated 2 issues for determination. I'll keep reading out the arguments of counsel. The second defendant filed his final written address on the 26th day of July 2021, arising therefrom, the counsel to the second defendant, L. Wike Esquire, formulated 2 issues also for determination. I also skip reading out the arguments of counsel and move to the cross of the matter. So in view of all of the foregoing, I have carefully evaluated and understood all the processes filed by the parties in this suit. I have reviewed the testimonies of all the witnesses called by both parties, watched their demeanor, and carefully evaluated the exhibits tendered and admitted. I've also taken into consideration the submissions of learned counsel to the defendants in their respective final addresses. I reckon that the counsel to the claimant posited that he did not file a final address as there was no need to do so. Arising from the totality of the issues raised and argued by the learned counsel in the final address for the first and second defendants, the issues for determination by this court are: 1, whether or not this suit is statute barred and therefore robs this court of jurisdiction, and 2, whether or not the claimant is entitled to the relief sought in view of the facts and evidence for the court. Before resolving the foregoing issues, I find it apposite to address the status of Exhibit D3, which was admitted under protest. The said Exhibit D3 was tendered by the counsel to the claimant through DW1, while the objection was raised by the counsel to the second defendant on the ground that the exhibit is a public document which failed to comply with Section 102 of the Evidence Act as it was not certified. Counsel to the claimant responded that the said document is pleaded in paragraph 5 of the claimant's statement of fact and paragraph 3, sub 3 of the defendant of the DW1 witness statement on oath dated 2nd of July 2019. Upon a consideration of the foregoing, I've taken a look at the said Exhibit D3 to find that same is a copy of the Greater Port Harcourt Development Authority Law number 2 of 2009. The said law was admitted by the first defendant to be the law establishing the first defendant and is on the basis that considered relevant for the determination of this suit. Pursuant to Section 12, sub 2B of the National Industrial Code Act 2006, I find it imperative to jettison the application for the provision of Section 102 of the Evidence Act as canvassed by counsel to the second defendant and to admit that the said Exhibit D3 in evidence in the interest of justice. I now turn to issue 1, which is formulated in view of the contention by counsel to the second defendant via his final address to the effect that this suit is instituted by the claimant is statute barred as it was instituted outside the 5 years period stipulated by Section 16 of the Limitation Law, Cap 80 of the Laws of Rivers State of Nigeria, 1999. I must posit that I reckon that the claimant did not respond nor react to this contention. However, it is imperative to consider the objection to the jurisdiction of this court, as any decision arrived at without jurisdiction will amount to an exercise in futility. This much have been the position of the law as the court in the case of Ardo and another against Inyako and others, 2013. Citation supplied where the Court of Appeal held that, and I quote, "It is right that jurisdiction is a fundamental and threshold matter, the lifeblood of the adjudication, which when raised, the court ought to determine same before proceeding with the consideration and determination of the substance of the case. Where a court lacks jurisdiction to entertain a suit, the entire proceeding is a nullity, no matter how well conducted. It has also been held that it is the claim of the plaintiff, in this case, the statement of claim and the relief sought by the appellant that determines the jurisdiction of this court. Please see the case of Inakodri against Adeleke, 2007, citation supplied. Ugwe against Rarume, 2008, citation duly supplied, end of quote. Arising from the foregoing authorities, it is imperative to note that when deciding an objection to the jurisdiction of the court, it is a statement of fact, as in the instant case, and relief sought that should be considered to determine whether or not the court lacks jurisdiction. That said, I must quickly add that I'm not oblivious of the general position of the law with regards to limitation law is as held in the case of Alhaji Dr. Ado Ibrahim against Alhaji Megida Lawal and others, 2015 citation supplied, where the Supreme Court held that, and I quote, "It follows that where there is a statute of limitation prescribes the period within which an action must commence, legal proceedings cannot be properly or validly instituted after the expiration of the prescribed period. Where any action is statute barred, a plaintiff who might otherwise have had a cause of action loses the right to enforce it by judicial process because the period of time laid down by the limitation for instituting such an action has elapsed," end of quote. This general provision notwithstanding, I reckon that there are exceptions to the said general rule, and this was affirmed by the court in Energy, Marine and Industrial Limited against the Minister of Federal Capital Territory and another, 2010 citation supplied, where the Court of Appeal held that, and I quote, "Even though Section 2A of the Public Officers Protection Act stipulates actions against public officers ought to be instituted within 3 months of this act, neglect or defaults complained of by an aggrieved plaintiff, there are some exceptions to the general position of the law." For example, the law is not applicable in cases of recovery of land, breaches of contract, and claims for work and labor done. End of quote. There is no gainsaying that the provision of Section 16 of the limitation law of Rivers State, as cited by the council to the second defendant, is also a limitation which has exceptions to its general application. Consequent upon the foregoing, I reckon that counsel to the second defendant considered the course of action in the instant suit to have arisen from paragraph 11 of the claimant's statement of facts, where it was stated that sometime in October 2013, the claimant received a letter from the administrator of the first defendant purporting to remove him from office as secretary to the first defendant's board and authority. That notwithstanding, I am mindful of the fact that the claimant, by the relief presented before this court, is also seeking for the payment of an outstanding severance and redundancy benefit, as what was paid to him was far less what he considered himself entitled to. In view of the second relief sought before this court, I must state that part of the claims of the claimant arise from labor for work done, and that exempts the suit from being status barred. More so, the Supreme Court in the case of NRMA and FC against Johnson 2019 citation supplied held to the effect that contract of service is not affected by Section 2A of the Public Officers Protection Act, which is a similitude of the limitation law as cited in the instant case. Consequent upon the foregoing, the objection of to the jurisdiction of this court in the instant case lacks merit, and same is accordingly discountenanced. Issue 1 is accordingly resolved against the second defendant and in favor of the claimant to the effect that the instant suit is not statute barred, and this court is properly clothed with jurisdiction to entertain this suit, and I so hold. I now turn to issue 2, which is in respect of the relief sought by the claimant before this court. With regards to the said reliefs, I reckon that relief 1 is a declaratory relief. The said relief reads thus: a declaration that the forceful removal of the claimant from the office as secretary to the board of the first defendant and not in keeping with the procedure for removal of the secretary of the board as contained in the law establishing the first defendant and the approved staff handbook of the first defendant, and thus a breach of contract. With regards to a claim for declaratory relief, the court in the case of Diamond Bank PLC against Yahaya and another 2011 citation supplied, the Court of Appeal held that, and I quote, the law is settled that the court do not grant declaratory reliefs based on the admission of the defendant. The plaintiff must satisfy the court by cogent, credible, and convincing evidence called by him that he is entitled to the declaratory relief. So where the plaintiff on his own evidence fails to prove his claim for declaration, his claim must fail. Please see the case of Anyaro against Mandela's 2007 citation supplied, and Dayako against Dantoro 2004 citation duly supplied, and of course this par Onyamenam JCA of blessed memory. In Matomi and orders against Dada and orders 2013 citation supplied, the Supreme Court also held in respect of a declaratory release thus, and I quote, I agree with the learned counsel that the plaintiff must establish their claim on the strength of their case. They cannot place any reliance on the weakness of the defense, if any. The burden of proof on the plaintiff in establishing their declaratory relief to the satisfaction of the court is quite heavy, in this sense that such a declaratory relief is not granted even on admission by the defendant, where the plaintiff failed to establish their entitlement to the declaration sought by their own evidence. Please see the case of Nwa Kidu against Okaru 2010 citation supplied, and Tata against Mohammed 2002 citation duly supplied, and of course this for Pabi JSC as it then was. Upon the consideration of the fact that the claimant through the said relief 1 is seeking for a declaration that his removal from office was forceful and not in accordance with the procedure laid down in the law establishing the first defendant, I find it apposite to also mention from the onset that irrespective of the type of employment, the burden is on the employee to place before the court the terms of his employment and also establish how the terms were breached. The court in UTC Nigerian Limited against Peters 2009 citation supplied, where the Court of Appeal held that, and I quote again, it is fundamental and it is a fundamental, it's a bedrock on which any claim predicated thereupon ought to rest squarely. Thus, Where an employee, as in the instant case, complains of a wrongful termination of his employment, he has the onus, 1, to place before the trial court the terms of the contract of employment. 2, to prove the manner in which the terms were breached by the employer thereof. Please see the case of Garba against KIC Limited, 2005, citation supplied, and Jumbo against PEFM, 2005, citation to be supplied. End of quote. This passes Lawa JCA as it then was. In the face of the burden relied upon and placed upon the claimant, I reckon that the claimant posited that his appointment in May 2009 as secretary to the first defendant was pursuant to section 10 sub 1 and section 3 sub A of Exhibit D3, and same was for an initial period of 4 years, renewable for another 4 years. Claimant also posited that his tenure for the first 4 years expired, and he continued in office until sometime in October of the year 2013, when he received a letter from the administrator of the first defendant, which removed him from office. In the face of the facts alleged by the claimant, he was not present at the trial to adopt his witness statement on oath, nor tender any evidence. However, counsel to the claimant tendered Exhibit D3 to the defendant's witness and said Exhibit D3 is the law establishing the first defendant. As found on page 3 of the said law, the tenure of office of the claimant, who is a member of the board of the first defendant, was to be for 4 years, subject to reappointment for another for a further term of 4 years and no more. The claimant himself averred that he exhausted his 4-year term, but was not given a letter of appointment for another 4 years. Rather, he was issued the letter removing him from office. Claimant neither pleaded nor tendered the said letter removing him from office, just as he did not tender any letter for the appointment into office for the second 4 years. In view of the foregoing and without much ado, I must state that notwithstanding the failure of the claimant to present himself for trial, the claimant failed woefully, even by record, to establish how his removal from office was forceful or wrongful in view of the fact that he admitted exhausting his 4-year term in office. And upon his knowledge that his reappointment was at the discretion of the then governor, his tenure was not renewed. There is simply no basis for positing that he was forcefully removed, not minding the fact that there were no facts or evidence to substantiate the allegation of the use of force by the first defendant. Neither did he prove that the 2 conditions as required in UTC Nigeria Limited against Peters Supra. Consequent upon the foregoing, the claimant's claim for relief 1 suffers dearth of evidence and saying is accordingly refused. Relief 2 is for a claim for the total sum of 271,679 naira 86 kobo, being the outstanding severance, redundancy, benefits, and compensation for the forceful removal of the claimant from office as secretary to the board and authority of the first defendant, as contained in the report or claim for severance and other benefits prepared by his chartered accountant, Augustine U. Alozie, FCA. With regards to the said relief, I must state that the sum of 189 million comes within the realm of special damages, which must not only be specifically pleaded, but also must be strictly proved. As the court, in the case of Odovia against Akwa Ibom State Civil Service Commission and others, 2011 citation supplied, the Court of Appeal held that, and I quote, "It is the law that a party who claims special damages must not only plead it specifically, he must also prove it strictly." End of quote. This part read on JCA. Bearing the foregoing in mind, I must posit that upon evaluation of the entire set of facts presented by the claimant in a statement of fact, aside the fact that the claimant posited that the sum of 5,724,000, which was paid to him, was less than what he expected, there is no particularization in the statement of fact for how the claimant came about his claim of 189 million. That said, with regards to the claimant's attempt to prove the claim for 189 million by calling CW1 as a witness, and the said CW1 tendering Exhibit CW1A, which is an 8-page document titled Claims for Severance and Other Benefits by Dr. Silva Oposunju, Secretary to the Board and Authority of Greater Port Harcourt City Development Authority, Arising from page 5 of the said exhibit CW1A, I find that the table was presented bearing varying sums of forbearing benefit, redundancy benefit, unpaid salaries and allowances, and claim for loss of office, which amounted to the sum of 189 million, which is the exact sum claimed in Relief 2. Before I, however, expend time on perusing the entire document, exhibit CW1A, I find it expedient to quickly take into cognizance the fact that during cross-examination of CW1, who perhaps is the maker of CW1A, admitted that the said exhibit CW1A was prepared based on the handbook of the first defendant, which was tendered as exhibit CW1B, and that the said handbook does not specify anything in terms of payment for the secretary, while the computation in exhibit CW1A was merely his own initiative. Also, the said CW1 admitted that the staff handbook, that is exhibit CW1B, which formed the basis for the computation of the claimant's claim as captured in exhibit CW1A, is inapplicable to the claimant. For the sake of emphasis and abundance of caution, I've painstakingly perused the provision of section paragraph 3, sub 2 of exhibit CW1B and find that same provides thus, and I quote, the secretary to the board or authority shall be appointed by the governor of the state and shall not be covered by this manual. In addition to the foregoing, I reckon that exhibit D3, the law prescribing the first defendant on page 3 stipulates that the chairman and members of the board shall be paid such remuneration, emolument, and otherwise on such terms as the governor may direct. The foregoing means that there's no specified sum for the claimant as secretary, as remuneration and emolument of the claimant was at the discretion of the governor. The foregoing clearly shows that there is no basis for the computation of the sums claimed by the claimant in Relief 2, as the manual relied upon is clearly inapplicable to the claimant. Consequent upon the foregoing, I find and hold that the claimant has woefully failed to plead and prove that he is entitled to the sum claim, severance or redundancy benefits and compensation. The claim as made in Relief 2 is accordingly refused. Relief 3 is for general damages. And in that regard, I must state that as discerned from the facts for this court, no scintilla of wrong was done to the claimant to warrant the institution of this suit. Neither was there any contract breached by the defendant to warrant the claim for general damages. The appointment of the claimant and expiration of his term of office as contemplated by statute establishing the first defendant, and since his reappointment was predicated on the pleasure of the governor, the claimant cannot complain about the refusal to reappoint him. Consequently, there's no basis for a claim of general damages as sought by the claimant. Hence, the said Relief 3 accordingly fails. Having addressed all the heads of claim, there is no gainsaying that issue 2 formulated for the determination of this suit is resolved in favor of the defendants and against the claimant. To this court, the claimant is not entitled to the relief sought. In the final analysis, the case of the claimant is found to be devoid of any scintilla of merit, and same is accordingly dismissed in its entirety. Judgment is entered in favor of the defendants and make no order as to costs. Thank you, gentlemen.
We are much obliged to the Honorable Court. Thank you, sir.
No.